Good evening and welcome all. On behalf of my Court of Appeals colleagues, Judges Saparik and Graffio, Reed, Smith, Piggott, and Jones, all of whom are here this evening, I'm delighted to welcome you to Court of Appeals Hall for what I know will be another exciting chapter in the Court of Appeals lecture series. These days, I must say, it is especially pleasurable for me as Chief Plaintiff, as well as Chief Judge. Thank you. To greet you and welcome you to our home, which in truth is your home too. Indeed, as some of our regulars here know, a fundamental objective of this entire lecture series has been to lure the public into Court of Appeals Hall, hopefully not only to kindle your pride in this beautiful public space, the most beautiful courtroom in the entire world, I submit, but also to stimulate your interest in the important work of our state's third branch of government. That work, profoundly affecting the daily lives of our citizenry, is regrettably far too little known outside the world of litigation. When Court of Appeals Hall was enlarged just a couple of years ago, we were able to fulfill a dream of offering this opportunity to the public to pay us a social visit, to see the court, to meet its judges, not on opposite sides, but on the same side of the bench, gathered around a legal subject that has significant social impact, as tonight's subject most surely does. And haven't we enjoyed a feast of fascinating issues and great presenters, beginning back in 2006 with the late SUNY Albany president, Kermit Hall, and the civil rights story behind the case of New York Times against Sullivan, followed by opera director Francesca Zambello and Brooklyn Law School professor Susan Herman's treatment of an American tragedy, centering on a case that was argued in this very courtroom precisely 100 years earlier. That inaugural lecture series was capped off by two of the world's preeminent architects, Henry Cobb and Paul Bayard, on courthouse architecture, including their unequivocal affirmation of my own declaration that this is indeed the world's most beautiful courtroom. And we surely followed precedent in the year 2007, adding to the phenomenal smorgasbord of speakers and subjects, United States Supreme Court Justice Stephen Breyer, and president of the New York City Harlem Children's Empowerment Zone and a leading educator, Geoffrey Canada, and noted legal commentator and author, most recently of the best-selling Nine, Jeffrey Toobin. The great National Basketball Commissioner, David Stern, was here to tip off the 2008 series with a talk on courts and sports. And tonight, he has passed the ball to two colleagues from an entirely different league, Owen Pell and Monica Dugo, here to talk about stolen art. I can say without equivocation that every one of our lectures has been a standout and a sellout, and I am thrilled to include tonight's speakers in this illustrious company. To assist in your legal education this evening, we have left two take-homes on your seats. Not take-home examinations, but take-home reading for you. The first is a brochure on a work of art that is very precious to us, and that is Lady Justice. In fact, Lady Justice not only adorns our courthouses, but these days is also flying high in the city of Albany on lampposts surrounding this courthouse on Eagle and Lodge and Columbia and Pine and Elk Streets. We hope you will pause to make her acquaintance. Also, we have distributed reports of decisions in 3 cases involving stolen art that actually came through this court, not the art, but the legal issues. The first, the Kraut case, is a suit against a warehouseman for ransom the owner had to pay to recover his stolen Russian enamels. The second, Guggenheim, involves the the statute of limitations in a suit by a museum to recover a Chagall work that had apparently been stolen by an employee. And the third, the grand jury case, centers on the Manhattan District Attorney's effort to detain for inquiry in New York 2 paintings that had been loaned to the Museum of Modern Art by a foundation in Vienna. Fascinating reading, all 3, I assure you. My wonderful friend and colleague, Judge Susan Phillips Reed, co-conspirator in putting together this entire lecture series, has the privilege of introducing tonight's speakers and tonight's program. Before turning this lectern over, however, I will take but a moment to convey my thanks to her, to tonight's speakers, to our co-sponsor, the Historical Society of the Courts of the State of New York, and to all of you for joining us. And finally, I offer congratulations to tonight's audience. You have made an excellent, excellent decision to spend this evening here with us. Thank you.
Just as a reminder, before I introduce the speakers, you should have found little white index cards and pencils on your chairs when you came into the courtroom. And the purpose of those is for you to jot down any questions you may have, because our speakers have graciously agreed to take questions at the end of their presentations. I'm very pleased to introduce Owen Pell, who is a partner at White & Case LLP, resident in New York City. His areas of practice include complex commercial litigation and litigation in the fields of securities and bankruptcy, as well as litigation involving foreign sovereigns and their state-owned entities, and involving issues of public international law. Mr. Pell also has extensive experience representing corporations and financial institutions in connection with investigations by the SEC, the Department of Justice, and state banking regulators. He has conducted numerous internal investigations for corporations and financial institutions, including with regard to historical reparation issues. Mr. Pell represented the Chase Manhattan Bank and Crédit Commercial de France in class actions arising from the activities of the banks in France during World War II, and participated in the successful negotiations between the United States and France to resolve those cases. He also has represented and advised foreign sovereigns and their state-owned entities in numerous proceedings and contexts. Recently, he successfully defended Poland in litigation relating to alleged property expropriations immediately after the Second World War. Mr. Pell has formulated a proposal for creating a title clearing and dispute resolution entity to address claims relating to works of art looted from individuals during the Holocaust. The proposal has received attention because it does not rely on the negotiation of a treaty for implementation, which would allow speedier formulation and establishment of the proposed entity. Mr. Pell has published widely on the subject of Holocaust-looted art, including in the DePaul Journal of Art and Entertainment Law and the papers of the Permanent Court of International Arbitration. Owen Pell is a graduate of the State University of New York at Binghamton, Harper College, and the University of Virginia Law School. His co-presenter tonight is Monica S. Dugo, who's the Director of Restitution and Senior Vice President at Christie's, where she coordinates Christie's restitution issues globally. Prior to joining Christie's, Ms. Dugo served as Deputy Director of the New York State Banking Department's Holocaust Claims Processing Office, where she coordinated the art claims branch of that office's work and assisted owners and heirs who were seeking to recover art collections that were lost or looted during the Nazi era. She has represented New York State on art restitution matters at venues including the Washington Forum on Holocaust-era assets and the International Conference on Holocaust-era looted cultural assets in Vilnius, Lithuania, as well as on the American Association of Museums Task Force on Holocaust-era provenance website standards and technology. Ms. Dugo serves as a member of the New York City Bar Association's Art Law Committee and is on the advisory board of Claremont McKenna College's Center for the Study of the Holocaust, Genocide, and Human Rights. Monica Dugo is a graduate of Barnard College. Our chief was happy to hear that, as she is also an alumna of Barnard College and the Cardozo Law School. I will now turn the program over to Owen Pell.
Thank you very much. It's a very humbling thing to be in this courtroom, given what happens here and given the decisions that have emanated. Judge Kaye, Judge Reed, members of the court, Monica and I are honored to be here tonight to share with everyone some thoughts we have on Holocaust-looted art. What we hope to do this evening is to provide two paths into the field. The first is empirical, by framing the nature of the problem. The second will be somewhat legal, by highlighting some of the issues that arise when claimants seek return of Holocaust-looted art. Now, the legal issues being addressed tonight generally involve what we call common law. That is, law developed by the decisions of judges, like those of the Court of Appeals, as opposed to statutes passed by the legislature. The common law, something brought here from England, is fascinating because, as opposed to statutes, which once enacted can be changed only by amendments which are often difficult to come by, can change with the ebb and flow of judicial decisions, by judges responding on the one hand to prior precedent and on the other hand to new and changing circumstances. There is no question that there is a tension in these principles, as too much change too often would weaken the law as a guide to behavior. But it has been widely recognized that part of the greatness of the common law is its ability to adapt. So as we unpack issues surrounding Holocaust-looted art, it would be useful to keep in mind something that Chief Judge Kaye once said, which was that the purpose of common law courts is always the same: case by case, to build on the past and anticipate the future, to establish a principle that resolves both the litigation and guides the daily lives of citizenry. To begin, we have World War II, which was a tragedy, obviously, on multiple levels. It was a war unlike any other in scope. Indeed, it introduced the world to the concept of total war, a war not just among armies, but literally among societies. Casualties beyond comprehension, routinely cited at 50 to 70 million dead. Unique levels of atrocities and crimes against humanity were committed to the extent that new crimes were recognized and prosecuted under international law pursuant to the Nuremberg Charter. It was also unique for the nature and level of looting of property. But what was especially unique was the relationship between the atrocities and the looting. The looting was beyond anything ever seen before. By some estimates, and Monica will talk more about this, by war's end, 20% of the art in the world had been looted to Germany. As Monica will also cover, the looting also knew no bounds, going well beyond the traditional notion of one state taking the property owned by another state as war booty. And then, of course, World War II was unique for the Holocaust. The Holocaust was remarkable first for its utter lack of spontaneity. It was carefully planned. It was systematic. And it targeted more than people. It was intended to wipe out all traces of Jewish identity and culture on the face of the earth, but certainly in Europe as a starter. In this, looting became integral. One way Jews were made to disappear from German society was that they were methodically stripped of all the things that give people a presence in a modern society: social security numbers, the right to work in a trade, the right to make a claim in court, rights in property, the right to live anywhere as opposed to a ghetto. Nazi theorists wrote that Jews had to be made to disappear within German society and ultimately European society so that when they were taken away to be killed, no one would really notice all that much, and hence the looting. As has also been documented by the great German historian Götz Allee in his seminal book last year, Hitler's Beneficiaries, the looting also served another pernicious purpose: wealth and property distribution within German society, both among Germany's leadership and to the German lower and middle classes. What we hope to cover tonight is twofold. Monica is going to provide an overview of the looting program before and during the war, the recovery efforts at the end of the war, and specific examples of how we are still today sorting out the problems created by Holocaust looting and why those problems are not going away. I will then try to look at how New York law wrestles with the problems created when legal doctrines relating to everyday problems of property loss are applied to an event like the Holocaust. I give you Monica to go to start.
Thank you. Following up on Owen's remarks, the widespread looting, which happened during the 12 years of Nazi dictatorship and during World War II, amounts to the greatest theft of art ever known. This may sound like hyperbole, but while it's difficult to estimate exactly how much art was affected, some estimates suggest, as Owen mentioned, that about a fifth of all art in Europe was spoliated or displaced during this period. Hundreds of thousands of works of art. The scale and the scope was unprecedented. So why did art play such a specific role, and what are the consequences 70 years on? Art and aesthetics was of enormous importance to Hitler and his second-in-command Goering, as well as other top-level Nazis, from the orchestrated displays of might and Nazi propaganda through to the coordinated acquisition of art for their grandiose projects. And it's this so-called acquisition of art which provided one of the two bases for spoliation or looting of art which was to happen after 1933. Firstly, Hitler had intended to build the greatest art museum that the world would have ever seen in Linz, his birthplace. It would have been called the Führer Museum. Ultimately unrealized, it was meticulously planned, and a team of art historians and museum directors were appointed to handle the acquisition of art for it, art which reflected both Hitler's own taste and promoted the German Aryan ideal. This did not, of course, include modern or degenerate art, art that was deemed too left-wing or too Jewish. Such art was in fact stripped from Germany's museums during the 30s, held up for ridicule, and its advocates exiled. To fill the Linz Museum, the finest Jewish collections were plundered, not merely as a consequence of war, but actively legitimized by official Nazi policy towards Jews, first in Germany and then the other countries that the Nazis were to occupy. Goering, too, was an avaricious collector who took full advantage of confiscated Jewish collections to build his own collection at his hunting lodge at Karen Hall. Perhaps more fundamentally, the widespread spoliation of Jewish collections was a means of persecution, either directly through confiscation of property or indirectly through, for instance, forced sales of collections by Jewish collectors in order to meet the crippling and often bogus taxes that the Nazis imposed upon them, such as a notorious flight tax or to raise funds for immigration. And to put this into context, anti-Semitic sentiment and laws were put into force in the first few weeks of the Nazi regime. For example, organized boycotts of Jewish businesses and the move to strip Jewish professionals, lawyers, doctors, civil servants from their posts. Later, such measures would lead to the infamous Nuremberg laws, Kristallnacht, and then to an active gathering of information on the part of the authorities into Jewish property, which would be used as a means of confiscation and asset stripping. Art was very much tied up in this, and in this vein, there's an extremely close link between looted art and the Holocaust. Eradicating an entire people and their heritage went hand in hand. And it's very important to bear in mind that while Hitler picked out masterpieces for Linz, it wasn't just museum-quality works that were spoliated. It was a whole range of objects from ordinary middle-class collections, not just paintings, but books, manuscripts, sculptures, tapestries, silver, coins, and so on. To give you a brief example of how this persecution worked in practice, let me get this right, yeah. Here's Professor Kurt Glaser. He was a respected art historian and museum director in Berlin. He was a World War I veteran and a popular dealer on the German art front. Being Jewish, he was removed from his post in 1933 as part of the cleansing of the professions. And like many in his position, he decided to emigrate, raising funds by selling his art collection and his library in order to do so. And it's exactly this sort of sale, which in the reappraisal of Nazi-era art looting, which has taken place these last few years, that is now viewed as potentially invalid on the grounds of duress. In fact, this was acknowledged to be the case for this painting by Corinth, which was restituted in 2007 to Glaser's heirs by the city of Hanover, in whose collection it had been since 1949. The information-gathering imperative on Jewish assets, which had begun in Germany, became a full-blown coordinated project in Austria. Very swiftly, after the Anschluss in March 1938, Austrians had to complete property declaration forms, detailing all their assets, including art collections. Targeted confiscations were soon in full swing. The Rothschilds' residences, for example, were seized immediately, and many of the old master pictures in their collections earmarked for Hitler. And so you begin to see a pattern of confiscations and forced sales emerging that by the time of the invasion in Czechoslovakia, Poland, the Netherlands, France, had become a deeply entrenched, coordinated program of spoliation wherever the Nazis operated. An entire structure of looting units operated to identify and confiscated looted art, alongside opportunism and threats as other means of disappropriation. Such looting units are best illustrated by the work of the Eisenstab Reichsleiter Rosenberg, or the ERR, primarily working in France. Headed by Hitler's chief ideologue Alfred Rosenberg, it was again a team of art historians and bureaucrats tasked with a special mission of confiscating Jewish collections. Based at the Jeu de Paume, it was ruthlessly efficient in confiscating objects for the Reich from the houses and bank vaults of France's Jewish collectors. Just to give you a sense of the scale, from January 1942 to August 1944, in Western Europe alone, the ERR raided 71,000 Jewish homes and sent back to Germany 29,436 rail cars of loot. Over 3 million manuscripts and books were looted. Its approach successfully targeted over 200 key collections and corralled nearly 22,000 works. Again, much was shipped to Germany for either Hitler or Goering, and Goering himself was a regular visitor to the Jeu de Paume to select works for his collection or to barter with modern or degenerate works that went against the Nazi grain so that he could acquire old master pictures. The slide here shows some of the modern works of art that was later, and this room was later dubbed the Salle de Martyrs, works from the collections of important Parisian collectors like the Rosenbergs, Seligmans, Kahns. And it was not just in Paris that collections were looted. The collection of John and Anna Jaffé in Nice was confiscated by the pro-Vichy regime and forcibly sold off in 1943 as Jewish property. This important Turner being just one of the paintings lost by the family in this way. It hung for years in the Kimball Museum in Texas before its restitution last year, and interestingly, although it was sold last year, it ended up being reacquired by the Kimball Museum, bought it back. In the meantime, the art market was booming. It would be a misconception to think that all art activity or transfer of property beyond the Nazis' efforts during these years, specifically during the war, just stopped. Quite the contrary. The art market thrived, partly because the amount of money the Germans were willing to spend, and largely, again, through opportunism. Indeed, one post-war report suggested that 4/5 of Parisian art dealers were complicit in trading with the Nazis. While direct confiscation was a key tool in the Nazis' armory of dispossession, many Jewish collectors and dealers also had their businesses taken over in a process termed Aryanization, where non-Jewish dealers took over established concerns. A good example of this is the fate which met the collection of Jacques Houtstikker, who was a leading art dealer in the Netherlands before the war. Houtstikker knew what the invasion of the Netherlands would mean for his family and business. So in May 1940, he and his wife Desi and his son fled Amsterdam literally days before the Nazi invasion. They boarded a boat bound for the States, but Houtstikker himself tragically died on an accident on board. In Amsterdam, the business and his property were left unprotected. The employees left in charge of the gallery were soon joined by Alois Meidel, a German dealer and banker and a close associate of Hermann Goering, who quickly went on to forcibly purchase all of Houtstikker's assets, including his name, to trade under. Over 1,300 paintings were in the gallery's stock in May 1940, 1,000 of which were detailed in what is known as Houtstikker's Black Book, his stockbook notebook, which fortunately survived and has been an essential tool for the heirs in trying to recover their property, which they have been doing successfully. Shortly after the takeover of the Houtstikker Gallery, its assets were divided up. Goering purchased all of Houtstikker's art for a sum which he later boasted was an absolute snip. He said this at the Nuremberg trials. From there, he picked what he wanted for his collection. What he didn't want was sold either in the Netherlands or in Germany at a time when the art market was booming. And Meidel continued to run the business during the war years. As a footnote here, although by no means to diminish it, it's also worth mentioning that although spoliation history and current restitution efforts and our talk this evening primarily focus on the consequence of Nazi looting from Jewish collections, other forms of looting took place during the war. The Red Army trophy brigades in the last days of the war took as much booty from the Nazis' hidden repositories as they could possibly carry. And there was also the opportunistic looting of American GIs, other Allied soldiers, and others. Lastly, it was not only private collections which were looted, but national collections and patrimony as well. We're also seeing, since the reunification of Germany, restitution cases for property nationalized by East Germany in the newly divided post-war Germany, and recently one case of Stasi confiscated art. By the end of the war, Europe's collections had been comprehensively plundered and scattered. Those works of art which were recovered by the Allies from the Nazis, for example, the Goering collection, discovered in a tunnel near the Austrian border, or from the mines used as hidden repositories for top collections, these works were gathered together by the Allies in central collecting points, roughly 20 million objects, collecting points in Munich, Offenbach, and these works were to be identified and sorted and then ultimately repatriated to their country of origin. And you'll imagine this was no easy task, which lasted for several years after the end of the war. Tens of millions of objects were processed through these collecting points. It was then the job of the countries in question to deal with the claims from collectors or their heirs for return of property. However, again, this was easier said than done. Many collectors had not survived the Holocaust. Survivors or their families might not have had the required proof to demonstrate that a particular painting had once belonged to them. And some countries took a firm line on restitution. Some countries sold off unclaimed art, but many of these returned artworks entered national collections, and many are still there today. The Louvre and other French national museums still hold an estimated 2,000 works of art. So although post-war restitution efforts were largely successful, the task remained unfinished because of the enormity of the job, the press of other business, and of course the onset of the Cold War. While dispossessed families may individually have tried to trace their former collections, the world by and large, with a few exceptions, and the art world in particular, swept the past under the carpet and just resumed business as usual. So what does this mean in practical terms for identifying and tracing spoliated art today, and what happens when we find it? Spoliated art, in all its forms, is not that simple to identify. For all the records of well-known collections like the Rothschilds collections or the Kahn collection, there are many more works of art that have entered the market over the years since the war without any reference whatsoever to prior owners or to provenance. Looted paintings and objects may have been bought and sold many times over the last 70 years across borders in various countries. Attributions and tastes might have changed. Artists who are valued now may have been less so in the 30s and 40s. And we're seeing that a lot with Egon Schiele's, for instance, and Gustav Klimt's, that were not worth the numbers that we're seeing right now. Their works necessarily would have been less well documented. The heirs of former owners might not have had enough information to specifically identify a work of art, particularly if it depicted a common theme by the artist. An inventory noting a Renoir portrait, while helpful, is not sufficient to identify one portrait from the hundreds of portraits that Renoir did. And with provenance often unclear, even scholarly publications may not be able to give a comprehensive history for a painting. Items from pre-war collections can surface in the hands of dealers, governments, collections all over the world, and Nazi-looted art continues to be passed on, often inadvertently, as these displaced works pass from one generation to the next, or are offered through the art market. So what does the legacy of the Nazis' policies towards art objects mean for the art market today or for an auction house like Christie's? In fact, restitution, with its mix of legal, ethical, and commercial concerns, has become one of the most challenging issues we face. Christie's, in common with other high-profile auction houses, is perhaps the most visible and public part of the art market. There's a constant flow of works that pass through Christie's. About 200,000 objects are offered a year. This makes it inevitable that we're going to see looted art. As a result, we're actively involved in due diligence work within Christie's, and we've developed internal tools to help in identifying potentially problematic objects. We work closely with claimants, restitution organizations, archivists, historians, and organizations like the Art Loss Register to try to identify potentially problematic pieces. Some of the spoliated objects we've seen over the years are quite varied, as you can see here. The Kirchner that you see to the left, top left, was stripped from the collection of the Städtischen Museum in Dresden because it was considered degenerate. And this Van Haarlem on the top right was confiscated by the Stasi from its owner in the then East German part of Berlin. For years it hung in the Gemälde Gallery and then in the Bode Museum in Berlin until its restitution earlier this year. Other works on the bottom come from the collection of Eugen and Fritz Gutmann, prominent Dutch collectors, and were restituted. What we sell and how we sell it is under constant examination, in addition to potential buyers seeking the reassurance of a clean bill of health before investing their money. Claimants, their representatives and advocates, organizations also pay close attention to the art market. Our primary aim, underpinned by research, internal resources, education, and company-wide awareness of the issues, is to ensure that we don't knowingly sell looted art. Owen will look at how the law has dealt with these displaced objects, as he mentioned. If a painting has changed through many hands in many countries since the point of spoliation, there could be a number of laws which can be invoked either in support or in defense of a claim if that's the route that the dispute is going to take. There's a great disparity among the states and nations, and it has been said that looted art cases often turn on the sheer happenstance of where the art has come to rest. Depending on the claim, litigation may be the only way to reclaim Nazi looted property, but as is evident from the comparatively small numbers of lawsuits filed on the World War II looted art front, litigation may not always be the most productive avenue for reaching fair and appropriate solutions to these types of cases. The emotional and financial costs associated with litigation are high and may indeed often outweigh the value of the item in question. Holocaust-related art claims have the unique history that the theft was connected to the murder of millions. And this history makes claims highly emotional and often difficult to handle under normal legal standards. When Christie's receives claims or identifies possible claims for looted art, our goal is to facilitate a dialogue between consignor and claimant and to help find equitable solutions, often with successful outcomes. Nazi-era spoliation can be a complex field. Consequently, each claim needs to be reviewed on a case-by-case basis. And obviously, Christie's cannot adjudicate these cases. But not surprisingly, most cases are resolved by some kind of creative settlement. And we've been privileged to be involved in trying to find positive outcomes to these types of cases. It's often open dialogue which resolves claims. For an unwitting owner, hearing the real story behind his or her artwork can bring about a willingness to compromise. Likewise, a claimant may be sympathetic to an owner who has only recently acquired the work with no knowledge of its prior history. Indeed, the vast majority of holders of looted art, in this instance our clients, have no idea of its earlier provenance, and it's therefore often the case in the claims that we handle that there are two innocents, the original owner and the good faith purchaser. Constructive dialogue, which allows each party to understand and respect the other's position, has often led to pragmatic and often leads to pragmatic, fair, and non-litigious endings for all involved. I'm going to end by giving two examples of where this happened. This work, Peter de Greber, was consigned to us for sale in early 2006, unsigned, unrecognized, and damaged along the way. When Christie's first offered this for sale in March 2006, we did so under the attribution of anonymous 18th century English school. Days before the sale, we were contacted by the Art Loss Register, who alerted us to the fact that they had an image on their database which appeared to match our lot. On closer inspection, it was indeed revealed to be a painting featured in one of the Polish catalogs of war losses, attributed to the artist Peter de Greber. We quickly withdrew the painting from sale, and shortly afterwards were contacted by the Polish government, which was keen to recover the painting. In fact, the painting was not one of those pictures taken from the walls of Poland's museums, although many hundreds were. Instead, it belonged to an art and antiques dealer in Warsaw, Abe Gutnier. Gutnier had been sent to the Warsaw Ghetto after the Nazi occupation of Poland, leaving abandoned his collection and his shop, which were soon confiscated. He and nearly all his family was murdered in the ghetto in 1942, but his son Ludwig survived. And it was to Ludwig's widow and children that the painting was eventually restituted following 2 years of negotiations between the owner, the Polish Ministry of Affairs, and Christie's. Both the heirs and current holder came to an amicable settlement which led to the painting's sale. So here you have an example of a painting lost in the chaos of the war, rediscovered, reattributed, and restituted successfully. And as a last example, this Schiele Herbstone, this was another case where Christie's was able to assist in identifying an issue and then putting client and claimant in touch through us. Before its rediscovery in 2005, this painting had been lost, presumed, or destroyed during the war. It had been in the collection of Viennese collector Karl Grunwald, who had been a close friend of Schiele's. Despite the Nazis confiscating his property shortly after the Anschluss, he managed to get a number of his paintings out of Austria, as again, the Nazis had no interest in this modern art, what they considered degenerate. Unfortunately, the collection was then confiscated from its storage in France after the occupation, and that was the last that was known of the painting until it turned up during a routine valuation in Christie's, France. Once a painting and the problem had been identified, the then owner asked us to make contact with the Grunewald heirs, who were shocked and delighted by the find. Following several weeks of discussion, and at this point there were about 40 Grunewald heirs, the painting was formally restituted to the Grunewald family. The painting was offered for sale and the matter was resolved. So I'll just end by saying that while some big steps have been taken these last 15 years in terms of the reawakening of the restitution issue, it's still unfinished business, and dealing with Nazi looted art is a great challenge, continues to be a great challenge. Owen will now focus on whether the law is up to the challenge of Nazi looted art.
Okay, so to recap, where we find ourselves during the war, as the war is unfolding, is that we have a unique problem. On the one hand, the victims are widely scattered, which is not always the case when things are being stolen. Here you had a people being rounded up from all over Europe and usually dispersed to places hundreds or thousands of miles from where they lived. The victims often will not be returning home. They will not be returning to the communities where, in some cases, especially if you're thinking of the less valuable things that might be looted, what in my family used to be called the tchotchkes, the china, the silverware, the reprint of something that hung in the living room over or over the fireplace. They might not be returning home to the parts of Europe, including parts of Europe where they were no longer welcome, after the Holocaust would be over. In addition, the objects would be widely scattered, and in fact, they would be scattered in ways that to the victims would be completely random, in part because of, as Monica said, the massive market that existed for moving all of this looted art out of German hands into the hands of others. And finally, Europe itself was in disarray in terms of the normal mechanisms, especially public mechanisms, that people would follow to pursue stolen property. You had a complete breakdown in terms of governments, court systems, and the like. Now, interestingly, the looting was no mystery. The Allies knew about the looting, in part because what you've heard Monica talk about. The looting was not only soldiers breaking into homes or the ERR breaking into homes. The looting started in 1933. The world had seen forced takings. The world had seen taxation masquerading as looting, or vice versa. The world had heard about Aryanization, how the Germans would reset exchange rates as soon as they conquered a country so that they could buy things more cheaply, and that they would then go up and buy in businesses and buy up inventories. So the Allies in 1943, after the war started, after the direction of the war began to change, the Allies issued the London Declaration of 1943, which was a unique event in international law. The Allies issued a formal warning. They included persons in neutral countries. They were aiming that one especially at the Swiss. They made clear that they would reserve to themselves the right to nullify property transfers, whether transfers caused by plunder or seemingly legal and voluntary transfers. What was then very interesting was that all of the final armistice treaties, and this was a first compared to World War I or earlier wars in Europe, all of the final armistice treaties had a provision that said that each of the surrendering states was responsible for collecting looted property, holding it as a custodian until its eventual return. So the concept of custodianship by states of privately looted property was actually built into the World War II armistice treaties. What's interesting about this, and this is particularly going to be important when we consider museums, right? Museums who are either state-run or receive a state subsidy as tax-exempt organizations. They're public institutions, and it raises an interesting question about being a custodian. What's interesting is this concept, which seems so novel to everyone at the end of World War II, was actually very old. Hugo Grotius in 1625 had written, "But things taken in unjust war are to be restored, not only by those who have taken them, but by others also into whose hands they may have by any means fallen." What was interesting was this was actually not a new concept that was revived at the end of World War II. Now, what did the United States do The United States also recognized the looting. There was a pioneering woman in the State Department. Her name was Ardelia Hall, and she really made it her life's work after World War II to focus in on the issue of Holocaust-related looting. And this is the only time I've ever heard of the United States really doing this, even more than when we freeze assets today. The State Department in the 1950s, on 3 occasions, actually publicized the idea that it was officially United States policy to recover and return looted property. And that was property not only looted and stolen, but improperly dispersed, which is supposed to take in the idea of forced sale and otherwise. The circulars covered American institutions and American citizens, and interestingly, the United States government actually circularized universities, museums, libraries, art dealers, and booksellers to try to put the market on notice that looted objects should be returned. So now that we have that as background, we turn to brass tacks. How do claimants actually get their property back in New York State? And the answer is replevin. Replevin is a development out of the old common law. It's one of the original great writs. And to plead a replevin action in New York State, the claimant simply has to say, I have a right to possess this object. I am the true owner. It has been wrongfully or in an unauthorized fashion taken from me. The person who is holding it now isn't authorized to control it. I have made demand, which demand has been refused, and I'm entitled to return or the value of the property. Sounds fairly simple and straightforward. In addition, in New York, we have basic rules, and those basic rules include the fact that generally a thief cannot convey good title. So as something runs from the thief to a seller, to a seller, to a seller, to a seller, the good news is if the true owner shows up, all of those people have inferior title to the true owner. The thief cannot pass good title generally. But we have the idea of what can be called an innocent purchaser, a good faith purchaser, a bona fide purchaser. The idea being someone who takes not knowing the goods are stolen, someone who pays value and the value is good and true value, what is something worth as opposed to a diminished value because you know it's stolen. And oftentimes in the law, innocent purchasers can win even against true owners, and that is especially true with regard to disputes between merchants over commodity items under the Uniform Commercial Code. So the idea is, as we call them BFPs, bona fide purchasers, do have special rights under the law sometimes, and the status can often be dispositive in cases, and we will come back to that. So you make your claim in replevin, but life is never easy, and Holocaust looted art claimants face many challenges. We don't have time to go into all the challenges here tonight. Indeed, I can tell you, just proving ownership, just getting over the first element, proving that you were the true owner or someone in your family was the true owner, can be very hard, as Monica has outlined, because of misattribution, the passage of time, bad record keeping, etc. But the reason I've highlighted these 4, they're of interest because they can even frustrate the case of someone who can prove they're the true owner of art looted during the Holocaust. So these were the issues I wanted to deal with because each one raises very interesting policy and legal issues. And as to each one, as we talk about them, one of the things to keep in mind is the tension between formal legal rules and flexible legal rules. So the first one, what law applies? Just because you bring your lawsuit in New York does not mean that New York law will provide the rules that decide your case. Instead, the court will have to look and decide what rule of law should apply to give you your rule of decision. Now, in New York State, the old rule used to be that we would look to very formal factors. Where did you slip and fall? Where was the contract negotiated and signed? Where was payment due? They're very, very formal rules. Where did the car accident occur? But starting in the 1960s, the New York Court of Appeals began moving New York law away from these rigid and formalistic approaches to a new test. And the new test was about looking to which state or country had the greatest interest in having its law applied, in part by looking to which states were connected in the greatest way to a claim. Now, the reason this is important in the looted art world is because the choice of law, especially non-New York law, can often be case deciding. It can often be dispositive. For example, if you steal something and you go to Switzerland and you keep it in your basement for 5 years, that's it. You own it. The statute of limitations has run, even if it's been out of public view. Because in Switzerland, someone has 5 years to find stolen property, period, full stop. There's no tolling of the statute of limitations. There's no way to get around it. It's just a rule. So if you can get a U.S. court, as Judge Pauly down in the Southern District did earlier this week, to rule that Swiss law applies to a Holocaust looted art case, well, then the statute of limitations will probably run and the claim will be cut off, even as to a true owner. French law can be very similar. Now, New York courts have tended to look in regular stolen property cases to look at, well, where did title last pass? Where was the good last sold before the claimant showed up? And maybe that's the state with the greatest interest. But in Holocaust cases, we should ask ourselves, does that rule really make sense? What about the Allied policy about recovery and return? Does France really care about a painting looted by French or German authorities during the war and sold several times before coming to New York? Does France care whether its law applies to that dispute? Does Switzerland, having allowed looted art dealers to move back and forth across the borders between France, Germany, and Switzerland throughout the war, really have a reasonable expectation that its law should be applied to cut off the rights of true owners because their picture just happened to be sold from Germany to Switzerland during the war? This is an important question that has actually not yet been resolved by the New York courts. Next is the question, well, when do I sue? When do I go ahead and sue? Now, New York actually has taken a fairly enlightened view. New York, we have the rule of demand. What the rule of demand says, and this is not actually, if it is the majority rule in the United States, it's only maybe by 30 states to 20 states, the last time I checked. The rule of demand says that if your property is taken and you come upon it, you have 3 years from the time you've come upon it to make demand for its return. It's a fairly simple and straightforward rule. Other states, for example, the state of Washington, where I had to litigate to get back the Rosenberg Matisse, which was a looted work that was talked about in Hector Feliciano's book, The Lost Museum, the state of Washington uses what's called the diligence standard. Now, the diligence standard says when your property is taken, you must diligently search for it. And whenever the court decides you should have found it, that's when the clock starts running. And if time ran out before you brought the suit, well, tough. If, on the other hand, you managed to find it in a period of time where the court thinks is reasonable and you made your demand and you brought your suit, well, then that's fine. But the issue becomes an issue of fact for the trial court as to what is diligence. And diligence is a very difficult standard, in part because of the nature of the scope. Some courts have taken the position that claimants must have scoured the world. They expect you to actually have looked at all the art catalogs in North America and South America and Europe to try to find your work, as opposed to just looking, for example, in the country you came from. So it's a very, very difficult issue. Now, in addition, what about delay? I mean, Monica and I are talking about cases that are now 60 years old, maybe if it's from the 1930s, 70 years old. These are very old cases. Now, what is the effect of delay before demand? In the law, we have a concept that grew up in the 1300s in England called laches, which basically says if by delay you prejudice the person you're now suing, that delay may be held against you and may actually be a defense and may cut off your claims. And it was a laudable concept when it arose, because people do need to know what they can own and not own and what they can sell and not sell. Holders, current holders, often assert that claimants have not done the things they should have done to have been diligent. And so holders will say, here, I spent money on this, it's been hanging in my house, I love this painting now. I absolutely adore it. It's my most prized possession, and by the way, it's worth a lot of money. So it would prejudice me greatly if I have to give it back to you, even though you're the true owner. And so they will claim laches. And generally, especially when laches is claimed by an innocent purchaser, by someone who claims they are a bona fide purchaser, that can be a case dispositive issue, especially since the burden is generally on the claimant to show that they have acted in good faith. Now, the Lubell case, which was given to you as additional reading, as homework reading, the Lubell case is actually a wonderful discussion of how laches works. It does involve a stolen work of art, not a Holocaust looted work of art, but a work stolen from the Guggenheim Museum in the 1960s. And it really is a wonderful case, in part because this court wrestled with the issue of if someone is wrongfully holding property and they've had the joy of it for all these years wrongfully, are they really prejudiced if they finally have to give it back to the real owner? And it's a difficult issue, and this court actually spoke about it. It's a very interesting case, and you should read it because it's an interesting decision that wrestles with some of the difficult issues that come up in stolen property cases. But, you know, we should be asking ourselves, is there a good reason that Holocaust claimants did delay? Is their delay so unreasonable? And how does the scope of the looting and the nature of the way property was scattered affect the duty to be vigilant? How do you look for something when you don't know where to look? How do you know which rocks to turn over if you don't even know where the rocks are? And that's one of the issues that arise in Holocaust cases all the time. So then the question becomes, do these rules really make sense? Do these kind of rules make sense? In the post-war world, for example, can any buyer of art really claim, especially major art? Let's talk about major art. Let's talk about, you know, several tens of thousands of objects that are museum quality that are worth thousands and tens of thousands and even millions of dollars. Is it really that easy for anyone to claim to be an innocent buyer? Given what we know was publicized by the Allies during World War II, what was publicized by the State Department after World War II, and what has been written about over the last 20 or 30 years. Should someone claiming to be an innocent purchaser, when it comes to Holocaust art, should they have the burden of proving their good faith? Because as you'll see in the Lubell case, good faith is a two-way street. If you're going to claim laches, if you're going to claim the benefits of equity and laches because I was unreasonable in waiting too long, you are susceptible to a claim that you don't get the benefit to that to the extent you are in bad faith. And so query whether we should shift the burdens in Holocaust cases and make the claimant first, and make the true owner, the current holder, explain why they were in good faith. Is it fair to expect that claimants have searched the world, and what is reasonable? And then, of course, there are museums. Now, museums are fascinating. We all know how important museums are. They preserve culture. They create a place and an environment where people can appreciate and understand culture, where scholars can research art history and the history of a culture. And as you saw in the MoMA case, the Metropolitan Museum of, Museum of Modern Art case, which was also given out to you, under New York law, museums actually have a special protection. And that special protection is any time they take a work on loan, as long as certain paperwork has been filed under New York and federal law, a work of art on loan may not be seized while the museum has the property in its possession. And the museums will tell you that they have to have that kind of a law in order to get people to lend them works of art. Interestingly, this issue has come up in Israel right now. Israel is about to stage a show with works loaned from various countries in Europe. It is a show of art that all was looted during the Holocaust. It is purely a looted art show. Various countries in Europe, especially France, would not send their art to Israel until Israel passed an anti-seizure statute. So now we have the fascinating anomaly that if you go to Israel to see the looted art show, you see your family's art on the wall of the Israeli museum, you can't claim it there. They have to send it back to France, and then maybe you can claim it, and the French have a procedure, and maybe you'll win and maybe you'll lose, because France has a tough rule on statute of limitations. In any event, one asks whether the law should be changed. Should there be a carve-out for Holocaust looted property? But in any event, given the public duties that a museum has, Chief Judge Kaye handed out a case involving the Manhattan Storage Company, which was a custodian for a piece of art. It's a very interesting case, which I had never looked at before. But it raises a really interesting issue, especially, I think, interesting as to donated art. Think about donated art. Museums don't pay for that. They get it for free, and now it's donated, and they have it in their collection. Now, the question is, if it's looted, should they simply treat themselves as a custodian? Should they have a duty to simply say, look, I've been holding it for you, I've been wondering whether you'd ever show up, here it is. I can tell you the museums actually don't look at it that way, which I think is unfortunate, but the fact is, if they are truly custodians, they're really never supposed to own it. They have duties to hold and duties to maintain, but it's not clear that they ever really own it. And if one wonders whether we should presume that they should have to return property, assuming that by a preponderance of the evidence it can be shown that it's not really theirs or that it is Holocaust looted property. These are the kind of tough questions that we're really up against. Now, I think it's interesting to ask yourself, well, where do these rules come from? And how flexible should we really be? Well, interestingly, the common law roots of these rules makes a lot of sense. These rules had to do with certainty of title, and they had to do with the idea that owners should be vigilant. But let's think about the world where these rules developed. Most of these rules developed during the Middle Ages. And literally, we're talking about pre-Renaissance Europe. We're talking about 1300s to 1500s. And these rules existed in a time when, if you think about it, how most people probably didn't go beyond 15 miles from where they were born in the course of a lifetime. The world was a lot smaller place. And if you think about it, the rule does make sense. If someone takes my cow, doesn't it make sense that I should be held to some duty to look around and maybe make sure that Monica doesn't happen to have my cow in her yard? And if she does, I should have a duty to, in a reasonable time, go and get Bessie back. And if I don't, well, then I should lose my rights to Bessie. And if Monica wants to sell Bessie, that's fine. But that kind of rule makes sense if you think about it, because it's not unreasonable to think that people could be vigilant under that circumstance, right? The sheriff of Nottingham knows all the people in the Shire, and he might say, hey, isn't that Bessie? Isn't that Owen's cow? And there were so many ways for people to get property back. And we wanted commerce. Commerce was developing. The courts were solicitous of that. We didn't want to burden commerce. Nobody would ever buy used property if you didn't have rules to know that if you were an innocent buyer paying full price, that you were getting good title. So these concepts made a lot of sense. But it was interesting. I sent some colleagues of mine at my firm back into the dusty archives, and I told them to get very dirty, and I told them to go back and read a lot of very old English cases. And I told them what I was looking for was to try to understand, were there any exceptions back in the old days of chattel property law to these concepts? And believe it or not, they found one. And it had to do with horses, which when I heard about it actually made a lot of sense. And this is the horse exception, hence the picture of the horse and the live horse. The horse exception was very interesting. The idea was in Old England, courts started recognizing, law courts and equity courts started recognizing that horses were different. Because unlike your house, they can be led away in the middle of the night and, be 10 miles away by morning. And so over time, true owners started running around and saying, well, wait a second. You bought my horse, and that's not fair because I'm the true owner, and now I've come upon the market where the horse was sold, and I ought to be able to get my horse back. And somebody else says, well, wait a second, I was an innocent buyer. The courts started developing rules, and the rules were very interesting. Eventually, the courts developed rules which Parliament later codified, which talked about things like a horse had to be publicly exhibited for a certain number of hours before it could be sold at a fair or an open market. Whoever sold it had to keep records as to who they were, who the buyer was, and what the description of the horse was. And the records not only had to be maintained for a certain amount of time, but had to be available if the true owner came looking. So none of these closed auction house records. It was all open. The owner, on the other hand, courts would say, equitably, the owner had to have reported to the sheriff the theft within a certain number of months, or else they lose their claim. And you had to have 2 witnesses show up and swear on a Bible as to the idea that your horse was brown, white mark, rig around the ankle, that kind of thing. Absent this, absent proper records being kept, absent not having a certain amount of public exhibition, the true owner wins against the innocent purchaser anytime, anywhere, under Old English law. If you take the steps, if you take all these steps under the horse exception, the owner can actually get his property back even from an innocent purchaser, but only if he pays the purchaser what the purchaser paid for the horse. And that was the way England worked it out. And it's a very interesting lesson, I think, in how the common law adapted to changing circumstances, and a problem that they hadn't thought of when the initial rules as to chattel property were thought of. So we end, I think, where we began. Is there room for the common law to grow in a way to address the special facts of Holocaust claims? As Judge Kaye said, how do we want the citizenry to act? How do we want people to act? The nature of the separation of people from property and people from their home areas arguably should count for something. Maybe it makes sense to apply the laws of nations. Does it really make sense to apply the laws of nations that participated in the looting or the movement of stolen art, as opposed to New York law, where the art now sits? The fact that the world was on notice of the looting and the looting relationship to a grave injustice, the slaughter of millions, maybe that should be factored in somehow. The Allied policy of recovery and return. And what is the role of public institutions like museums in fostering the public and social value of not retaining or trafficking in goods that were looted as part of a proven genocide? As Justice Cardozo said, we know where we are. The question is, where are we going? These are not easy questions, but they are worthwhile ones, and ones that the common law may actually be uniquely suited to address because of its capability of flexibility. And with that, I want to stop, but I also want to put up, for anyone who wants to write it down, this is an interesting selected bibliography, the first 8 being works of nonfiction, the last one being an interesting work of fiction. But these are wonderful books, and if you read any selection of them, you will find that you know an awful lot about Holocaust looted art. Thank you very much for your time and attention. The Rosenberg Matisse is an interesting story because, well, it's on the one hand, it's happenstance, as Monica said, the happenstance of the Holocaust. The Rosenbergs were a prominent art collecting family, and actually many of the members of the family survived the Holocaust because they had enough money to buy their way down to southern France, right up to the Spanish border, and they bribed a group of the family members bribed their way onto a Polish fishing trawler that was leaving for London just before France fell. And the sailors from the Polish trawler just went across the border into Spain where they'd be safe, and the Rosenbergs went on to London, or some of them did. And many of their gallery records, they had slides of all of their paintings, and their gallery records were looted by the Germans, and half of them ended up in Berlin, and the other half ended up in Moscow, because the Russians only managed to sweep up half of them when they looted Berlin. But what happened was when Hector Feliciano had his book, he had a book signing down in Chelsea, in Manhattan, and at the signing, a young man came up to him and said, "I know where this picture is," and he pointed to a Matisse, a black and white photo of a Matisse for the lease. And we all said, "Well, where is it?" And he said, "It's in the basement of the Seattle Art Museum." And what had happened was that we were able to show with research that Hector Feliciano did, we were able to trace that painting from the wall of the Rosenberg Gallery to a vault in Bordeaux, where the Germans found it after putting a gun to the head of the family chauffeur. And they found in that vault 583 other works of art, including, I think it was 25 Van Goghs, including Water Lilies, Dr. Gachet, all the famous Starry Night, all the famous Van Goghs were in that collection. And they had an art historian from one of the local universities sit in the vault for several months, writing out all the things that were going to be looted, because the Germans always gave a receipt to the bank. And also they gave a receipt to the Vichy government, which wanted to keep track of what the Germans were taking so they could get their take too. So there was the receipt upon the looting, and then there were records that the OSS collected at the Jeu de Paume, where this particular work of art was traded by the Germans to a group of Swiss art dealers for some Fontainebleau tapestries that Goering wanted for his home. So then it moved into the hands of a Swiss art dealer who used to keep a famous atelier on Rue Rivoli. And then the Swiss art dealer sold it to another art dealer in Switzerland, the Nobler Gallery, which has a big place in Manhattan. And Nobler had an agent in France after World War II named Prager, and Prager in 1947 sold the work to a young man who had fought in Europe and was back in Europe with his bride in post-war Europe, and for $500 he sold him that Matisse, lying about the provenance at the time. And the young man was an heir to the McMillan-Lobdell lumber fortune, went back to Seattle, put it on his living room wall where it stayed for 45 years, and when he died, he donated it to the Seattle Art Museum, which never publicly exhibited it because it wasn't their kind of art, and so it sat in the basement, unloaned, donated, unloaned, unloved. And when we heard about where it was, we made demand on the museum, and the nature of the demand was we told them that we actually thought we had better title to this work than most people have to their poems, in terms of being able to trace it all the way back. And they refused the demand. We litigated with them for 6 years before they gave back the work of art, and that is one of the strongest claims any of us have ever seen. And it shows you exactly how hard it is for anyone to get back Holocaust looted art, even when you have a terrific claim.
Monica, you mentioned that you see this all the time. Could you give us some idea? You mentioned the number of works that Christie's flows through Christie's annually.
Right.
Could you give us some understanding, or what percentage, or how many, or?
It's hard to say, give a percentage, but certainly we're seeing more and more works with possibly a problematic provenance surface. We're at this point, and perhaps it's because of the generation dying out right now, or just lots of works changing hands. The art market is extremely hot right now. But we'll see something that's problematic, and maybe in every single sale at this point, not post-war and contemporary, but we'll see something that certainly contains a red flag. Again, once we look into it, I mean, provenances can have red flags, and once we do research, it might turn out not to be problematic in the end, or the picture, in fact, might have been looted, but actually restituted after the war, because again, there were, a number of works were restituted after the war. And the problem is that in the art market, there's never this focus on provenance, really, until fairly recently. And a lot of the publications are wrong, or have just have faulty information. So you have publications for the last 50 years that have been sort of copying the same provenance information from one edition to the next. The fact that the work was not restituted and is not reflected in a publication in the 50s, and that gets just sort of repeated. So, but basically, to answer your question, pretty much in every single sort of master sale or impressionist and modern sale, 19th century, we see something that we need to take a closer look at.
What kind of red flags? What kind of red flags do you?
It could be the name of a known victim. It could be the Goering, Hitler are red flags. A lot of the Nazi dealers have become, everyone knows their names. What we've done is we've tried to create internal tools at Christie's to do this due diligence work. And right now we have a database of about 13,000 so-called sensitive or red flag names. And again, it can be well known for sales that happened in the 36 or 37. Basically anything that would just trigger us to sort of further. But it's generally names of victims, names of known sort of Nazi dealers, or people who, or dealers who work with those dealers, known for sales.
Or locations in certain cities at certain years where you know that seizures where there were mass roundups of property and auctions occurred.
Basically, you see a transfer, in Germany or in Berlin in 1937 or 1936, you have to look closely.
This is for either one of you, I guess. Did the spoliation of art extend any significant degree beyond the Jewish populations in the occupied countries?
The answer is yes. Not so much in Western Europe. I think in Western Europe, non-Jewish looting was more state property, so the Germans coming in and taking things that belonged to the French state, or obviously religious objects like the Gentolder piece. But in Eastern Europe, where the Germans took the position that they were ultimately going to wipe out all the Poles, they just were going to do the Polish Jews first. But the idea was all of Poland was going to be wiped out. The plan was to wipe it out over 2 generations by separating men and women so they couldn't, quote-unquote, read, and by starving the population to death. And in Russia, certainly. In Eastern Europe, the looting extended far beyond the Jewish populations and included religious property, communal property, and non-Jewish property. But I think it's fair to say that it was mostly Jewish property as opposed to private property.
Is there a credible legal basis, or do these kinds of things come up with other kinds of stolen items, such as friezes or Egyptian obelisks, or?
I do both.
You do both.
The answer is slightly different issue, not as much. For example, as we were talking about at dinner, I'm one of those people who thinks the Elgin marbles stay in London, which doesn't make you very popular in the Hellenic Society in Manhattan, but which the truth is, the Ottomans owned Greece at that time. They were the sovereigns, and they actually sold for 25,000 or 35,000 pounds the Elgin marbles to Lord Elgin, who was taking them back to London because they didn't get blown up on the Acropolis, where the Turks stored gunpowder. So, I mean, that was a sale. It
was an unfortunate sale, but generally what you find with antiquities is that post-World War II, there were obviously there were very strict restrictions on the export of antiquities. And those especially started to come in just before World War II in some countries that had their independence. Since World War II, a lot of former colonies passed those kind of statutes. You've all read in the newspapers about people getting convicted and going to jail for bringing into this country under false pretenses looted antiquities. So you do see things in the antiquities, but really the issue there is the issue of state patrimony. The idea is the antiquity is what a state holds for the benefit of its people. And when you're the raider of the lost ark, when you go and you take the lost ark out of the place where you found it, you're really robbing it from those people, from the state itself. And so it's really the states that are coming after you and saying, give us our property.
The books that you have up there,
yes.
So many of these have been written in the past 15, 20 years. Is it a generational thing? Why has this become such a topic in the past 15 or 20 years? I don't remember ever hearing about it until some of these books came out and it became quite a hot topic.
I mean, one of the key reasons, in terms of the timing, it was a number of archives all over the world really were opening up around 95 and 90, or even earlier, with a lot of this information. And I think that's sort of when Lynn sort of started writing her.
Well, I think that there were actually a couple of things. One was the end of the Cold War. When the wall came down in the early 90s, I remember writing a memo to a number of my clients saying, you're now going to be sued for Holocaust-related claims. Because while the Cold War was going on, there were lots of dirty little secrets that didn't get talked about. For example, what the Swiss did during World War II. The fact that Austria was actually not the first victim. I mean, there was a lot of things that you could get away with during the Cold War that once the Cold War ended, you couldn't. Second, there was as Monica said, there's the opening of archives, and there's a twofold issue there. One is, you had all these Eastern European countries that, when the Iron Curtain was the Iron Curtain, there were no open archives.
Well, I know you mentioned the Stasi.
Right.
Nobody knew what the Stasi had.
Right.
But you had the Pushkin Museum, for example. The Rosenbergs couldn't go to the basement of the Pushkin Museum to find out that half of their business records were there until after the wall came down because the Russians viewed that as a state secret. In addition, Europe has funny rules about people's archives. If you were a public official, if you were a museum curator, when you die, all of the records that you kept at the museum when you were curator are part of your personal estate. But under the laws of certain European countries, that estate may be sealed as a matter of law for 50 or 75 years. And there's no way around that. And so a lot of those personal papers don't start coming out and start trickling out until the 90s. And there are other estate issues in Europe, even as private papers, that really made the 90s with the end of the Cold War. That's when you start to see a flood of information. But what's fascinating about Lynn Nicholas is that what she was looking at were declassified records in the National Archives that had frankly been open since the 1960s. But nobody was interested.
Yeah, I would also add to that then you started having a few very high-profile cases, like the portrait of Wally painting, and like two paintings that were in the Leopold collection. It was part of an exhibition at the Museum of Modern Art in 1998, and those were seized. And that really started, and there were a number of other high-profile cases, like one that Owen described involving Seattle. And that actually also triggered, really what it did, it basically announced to claimants who might have been trying to recover their artworks right after the war and who maybe their families had given up, that it was okay again to start pursuing these claims and start to go after artworks that might have been taken. And also, I mean, again, after the war, that generation wasn't so, they were just really interested in seeing who was alive. And I think it's what you're seeing is you're seeing a second and third generation grandkids who really want to know what was in their grandparents, great-grandparents' apartments. And that's really what's driving all of this right now as well. So,
I mean, Stephen Wiesenthal has said, Stephen Wiesenthal had an interesting comment, which was that if you were a Jew after the war, maybe you didn't want to go back to where you came from, because as you walk down the street, you would realize that the dust you were kicking with your feet were your neighbors, your relatives, and your friends. And that's all that was left of them. And so it was not unusual that Jews should want to leave and go to Canada, Australia, Israel, any place other than where they had come from, where they didn't seem to be wanted. And as Monica has said, that generation often didn't even speak to their children about what happened during the war, what assets they had, or what they had lost. And it was only until much later that a lot of that began to come out.
Last question, and this is for the chief. So what's next? How long are you gonna have this?
Well, okay, you take it from the commercial side, I'll take it from the legal side.
I mean, you don't see any end inside. It's funny, before there was a Washington conference on these Holocaust era assets in '98, and even at that time, everyone was talking about this issue was surfacing, and everyone, before it even really began or blossomed, so to speak, everyone was talking about when will there be a deadline for these cases, or when will this stop? And right now, I think on the restitution front, everyone's busier than ever. People are making, again, as more archives become available, as more books are being published. These are just some of the books. There's tons of books basically being published in Europe in the German language, in France, coming out almost every other week, every other couple of weeks on a particular collector. And so you're seeing more and more claims. I mean, you're hearing about more and more lawyers involved in this area. They're making claims that you've never heard, or errors that you've never heard before. So I really, and again, given the number of artworks I'm seeing that certainly have, potential problems or certainly raise questions, I don't think anyone sees any end in sight.
Well, especially when you consider that as soon as these new books come out and it shows, and the new books are showing things that no one ever knew before, that old information was incorrect information, maybe all of a sudden there's a claim that there was a justifiable reason for delay in suing someone. I think legally, these cases are going to continue to percolate, and I think they will especially percolate in New York State, because New York State is a center of the world art market. And I think that I wouldn't be surprised if we see cases percolating up to the Court of Appeals, including by reference from the federal courts in New York, where a lot of these cases often end up. I think we may very well see cases, especially on the choice of law issue, and especially on the latch issue, but especially choice of law, because it would change the complexion. I mean, just in the last 3 years, there have been, there was the Barton versus Openstein case, which got as far as the First Department, and then went back, and that was a choice of law case, and there have been 3 federal cases in the last 6 months where choice of law has been used as a way of cutting off claims.
Okay, so we have that to look forward to.
Absolutely.
We also have more immediately, we have a reception to look forward to. But before that, we want to all give you a round of applause.